Present.
Representative Agello.
Here.
Representative Batista. Representative Bennett.
Here.
Representative Caldwell.
Present.
Representative Casimiro.
Present.
Representative Corvese.
Present.
Representative Felix.
Present.
Representative Lombardi.
Present.
Representative Norrie.
Here.
Representative Place.
Present.
Representative Roberts.
Present.
And Representative Bella Wilkinson. Seven present, 6 absent. We have a quorum. I'm sorry. We have a quorum. 2 are absent.
Okay, welcome. This is the House Committee on Judiciary. It's Wednesday, March 10th, 2021, and we are in room 35 of the State House. We have several bills here tonight. I think there's 16 or 17, but what I would like is a motion and a second to hold all bills for further study.
So moved.
Second.
Made and seconded. Madam Clerk, will you call the roll? Okay.
Chairman Craven.
Aye.
First Vice Chair McEntee.
Aye.
Second Vice Chair Knight.
Aye.
Representative Agello.
Aye.
Representative Batista. Representative Bennett.
Aye.
Representative Caldwell.
Aye.
Representative Casimiro.
Aye.
Representative Corvese.
Aye.
Representative Felix.
Aye.
Representative Lombardi.
Aye.
Representative Norrie.
Aye.
Representative Place.
Nay.
Representative Roberts.
Nay.
And Representative Bella Wilkinson. The ayes have it.
Okay, thank you. The first bill we have tonight is House Bill 5858, sponsored by Chairman Shanley. I spoke to him earlier in the day. He thought that he would be up here for about 4 or 5 hours chairing a committee meeting and then be home with his son. I hope that's where he is, because he's not here, so I will dispense with an explanation other than the explanation I typically give, which is this is an act related to criminal procedure and county grand juries. It permits county and statewide grand juries to issue reports with review/acceptance by the Superior Court with a sunset date of July 1st, 2026. I presume that means that we would revisit the issue again as to its success or failure. We have, fortunately with us tonight, the Attorney General of the State of Rhode Island, Peter Nerona, who knows a little bit about this subject matter. And Peter, I'll defer to you. The floor is yours.
Thank you, Chairman Craven, and I want to thank Representative Shanley. I want to thank you, Mr. Chair, Representative Barros, and Representative Amore for sponsoring this bill, which I believe is an important step, would be an important step in improving transparency involving some of the cases that matter the most to Rhode Islanders. This bill would provide, in what I anticipate to be limited instances, a situation where, with court oversight, a grand jury could issue a report even where it did not return an indictment. In other words, in a situation where, even though the grand jury did not charge, the grand jury could issue a report to report findings and, I think most importantly, recommendations that would advance the public interest. You know, the grand jury is an old institution, and just so everyone knows, what it is, the public and for those members of the committee, although I suspect they are few that don't know what the grand jury is, but it is a group of typically 23 Rhode Islanders who sit in secrecy, and they hear evidence from prosecutors, and they decide whether or not a indictment or a charge should be returned or not. And they do that on a basis of probable cause. Is there probable cause to believe that a crime was committed and the person who would be charged committed it? Well, those deliberations happen in secret. The public is not allowed in. There are no cameras. It doesn't happen in a courtroom. It happens in the grand jury room. When grand jurors deliberate, they do so without the prosecutors present, without the court reporter present. So the only people in the grand jury room when grand juries deliberate are the grand juries themselves. It's a powerful investigative tool. It's a tool that is used in every case in the federal system and is used in our most serious cases here in the state system. But what it is not is a tool that provides for transparency. And there are some instances, and I think over the course of, say, a term as Attorney General, there might be one or two instances, hopefully not more than that, but one or two instances where a case is of significant importance, and yet the grand jury, for whatever reason, does not return an indictment. But where a grand jury explanation as to why they did not, and as I said earlier, perhaps might provide recommendations about how things could improve, would I think be beneficial to the public. So what am I talking about? I'm talking about cases, and we've had them here in the past, unfortunately, in Rhode Island, where, blue on blue shootings, cases involving alleged excessive force by police, institutional misconduct, which may not rise to the level of criminal misconduct, but at the same time warrants explanation, not only why it's not criminal misconduct, even though it might appear that way, it might strike some as appearing that way, or it should be a criminal misconduct, and yet it is not, either by virtue of the law or simply because the facts don't support it in that particular instance. What this bill would do would be allow a grand jury to issue a report explaining what they found and didn't find, explaining why the law did or didn't apply, and I hope would build confidence in the process. And this bill builds in due process protections to protect those who might be named in a grand jury report like this where no charge is returned. And those protections are these. Anyone who would be named in a grand jury report would be notified that they were before the report was released publicly. So in order for that report to be released, it would have to be filed with the presiding justice of the Superior Court. The court would give notice to anyone who was named, and that person could object to the release of either the report or the reference to them in the report and the circumstances around it, and would provide for a right of appeal from that finding. And so, we looked across the country to find the best grand jury statutes that we could. We worked to, I think, make this one better. There are 18 states that have such a report statute across the country. Federal government has a grand jury report statute. I think it's an incredibly useful tool to have in the toolbox. And I will tell you that I have had to forego using the grand jury in situations where I felt like transparency was critically important, including very recently last fall. Now, fortunately, in that particular matter, I didn't feel like I needed the grand jury to get evidence through compulsion. I was able to get all the evidence I needed to reach a conclusion without using the grand jury. But I worry about a case where I might need to use the grand jury to get evidence. The grand jury would not return an indictment, and I would not be able to explain why the grand jury did not return an indictment. And I care about that less for me, although it's obviously easier for me to try to explain how something happened when my office is directly involved in it. But it really matters more for public confidence. There are times when the public needs to be reassured that what was done thoroughly and carefully, and there's an explanation for what happened. And this is an opportunity to provide that. We have included a sunset provision so that if there's any concern that it's not going well, it would just end in 5 years. And again, I don't think this is a tool that would get used incredibly often. As I mentioned, I can think of, in my mind, in my own experience here, and even in the years just before my arrival, a handful of times where you might use it. But there are definitely times when we would use it. And so many times there are calls for transparency. And yet those calls come in the context of the grand jury context, where transparency certainly is just not possible. And this would fix it. And so let me leave my remarks there, but I'm happy to take any questions about this piece of legislation. And thank you for your time.
Any questions for the Attorney General? Yes, Carol.
Thank you, General, for putting in this bill again. I'm very supportive of this bill. The case that comes to mind is Pennsylvania and the Catholic Church sexual abuse that took place down there. And they did a 2-year grand jury investigation and did release the findings of that grand jury, not necessarily the names of individual priests, but they did release a lot of information that did allow Pennsylvania legislature to enact laws that protect children and stop institutions from this kind of abuse. So I do believe after the 2-year investigation, they did sign many laws into place. And there was such a public outcry to find out what that grand jury had discovered and how far-reaching the institutional abuse had gone at that time, that I think it served a very compelling public purpose to inform the people of Pennsylvania. Now, in Rhode Island, obviously, the thing that comes to mind is 38 Studios and how the public clamored for that information and still does. And of course, we can't give them that information. So it's just a comment. I think it's a great tool for you, General, and I would ask that the entire committee support this, because there are compelling interests that can be discovered, and not necessarily by exposing names of people that you don't return an indictment on. But it has compelling use and interest in the public, and they were able to use a lot of this information in Pennsylvania to enact legislation. So thank you, General.
Yeah, thank you, Representative McAtee. If I could I appreciate your comments very much. And if you think back to that Pennsylvania case, I think there were 2 or 3 priests who were indicted, and yet those 2 or 3 indictments did not in any way fully capture the entire scope of the misconduct that went on there. And if you can't capture the scope of the misconduct, then you don't know how to position yourself to improve it, as the Pennsylvania legislature did. So that is a perfect example. 38 Studios is another. That's an example of the public really wants information. But I know as a lawyer that the Supreme Court in that case, and Judge Gibney before the Supreme Court, under our current law, got that exactly right. And so we have a choice to make in that kind of a situation. Do we want transparency? Or don't we? And if we do, this is a means to get it. But we can't get it under the existing law. I don't think any practitioner who has worked a lot in the criminal justice space and understands grand jury practice can possibly conclude that legally the Supreme Court in 38 Studios or Judge Gibney got that wrong. If we want transparency in that context, then we need this fix.
Thank you.
Thank you, Representative.
Representative Knight.
Good evening, General, again.
Hi, Representative.
Hi. I haven't had a chance to really sort of absorb this. I've taken a couple passes at it. I just have one question. I know that there's a vetting process in the report that you would want to publish that has to go through the presiding justice. Does the bill allow the presiding justice to just in her discretion say, no, we're not doing this? Or is it you have to do it subject to these particular due process concerns?
No, the Superior Court can decide not to authorize release of the report. Now, my office would have an opportunity to appeal it under those circumstances, to appeal that decision, just as someone named in the report would have an opportunity to appeal as well. But the presiding justice could determine that the report should not be released, either right away or not at all.
So it's fair to say, and this is for the audience at home, that this bill contemplates a very close working relationship with the court to make sure that anything's disclosed is appropriately disclosed. Fair to say?
That's correct.
Thank you.
Any other questions of General Nerona? Okay. General, thank you very much.
Thank you, Mr. Chair. Thanks, everyone. Thank you for your time.
Good to see you.
Good to see you, too.
The next witness on this bill is Michael DeLauro from the Rhode Island Public Defender's Office.
Excuse me, Mr. Chairman. Could I ask a question of the lawyers here on this bill? Okay. Before you get it to Mr. DeLauro. I'm just curious. I like the bill. So, but I'm curious. So, would the report be able to be used? Let's say they found no no criminal
Liability.
activity, and they release the report. Could the report be used in a civil case against the defendant, against the principals?
Arguably, yes. Yeah. And that would be a reviewing point that the presiding justice would go through, because she probably would ask that question. How do you plan on using this? And if they say, we're going to pursue a civil proceeding. I can speak from personal experience as a former assistant attorney general in reference to the banking crisis. I personally conducted grand jury investigations with the assistance of the state police and the Bureau of Audits on issues involving Joe Malacone, for example. And there was another fellow named Len Dekoff, who had been hired by Bruce Sunley. And he had civil authority to recover all the money he could at a contingency fee. So if this process were available then certainly we would say, yes, Judge, we want to release this report so we can get an explanation to people about what happened and how it collapsed. But we want to turn it over to Lenny Dekoff, God rest his soul, because he's going to sue those responsible that he believes can lay out a negligence case. So,
Thank you.
thanks. Okay, is Mike on the phone? Mike?
Yes, I'm here.
You are on the air and you're testifying on the Attorney General's bill on grand jury proceedings.
Well, thank you, Mr. Chairman, and thank you, members of the committee, for hearing me tonight on this extraordinarily important piece of legislation. Let me first say a couple of preliminary things. I want to thank the Attorney General's office for providing us with some early drafts of this legislation back in 2019 when it was first drafted and submitted. My recollection is that I had a number of conversations with Ryan Holt about it and Mr. Danbrook also about this legislation. Secondly, although the public defender is not taking an official position on this legislation, I do come before you tonight to express some concerns about the legislation in its current form. So let me begin by saying what I think is obvious to everyone. This is a substantial piece of legislation that warrants careful attention to its details. The reason that I say it is a substantial piece of legislation is because our Supreme Court on more than one occasion has said in clear and unequivocal terms that Rhode Island has a common law grand jury. And what that means is that there isn't a whole lot in the way of rules and regulations regarding how the grand jury is conducted. And what we do have is law made by the courts, either in the way of court rules, which I'll talk about in a second, or decisions from our state courts. And really the legislature's involvement has been limited to things like when grand juries are summoned, the number of people that make up the grand jury, and the number necessary to return an indictment. So really all the substantive stuff, if I can put it that way, comes to us from the courts. And I think that is consistent with what the Rhode Island Supreme Court has said, which is, being that this is a common law grand jury, that it's a matter for the court to do these things rather than the legislature. So our concern is grounded really in this. Some of you who have been here for a while will recall that both in the past and under current law, the public defender has argued unsuccessfully, both legislatively and in litigation, for additional protections that ought to be afforded to those who are targets or witnesses before the grand jury. So, for example, one of the pieces of legislation that we put forward in the past would have required that exculpatory evidence or Brady material be submitted to the grand jury. The General Assembly thought long and hard about that, did not enact that legislation. We also litigated it in a case called State of Rhode Island versus Russell and Sidibe, and the Supreme Court said that there was no such requirement. So what we did when looking at what other states have done, and the Attorney General correctly acknowledges that they looked at other states in coming up with this idea, we think that additional protections need to be engrafted into this bill before it ought to become law. So let me tell you a little bit about what other states with similar statutory schemes as this, and I looked at about a half a dozen, including Pennsylvania. What have other states done in creating grand juries, in creating or allowing grand juries to issue reports like this? What I found was this. First, a requirement that witnesses or targets who have criminal exposure be advised of their Fifth Amendment rights against self-incrimination and Sixth Amendment right to counsel. Second, that grand juries in other states that are allowed to issue reports, there has to be a specification that the investigation is into organized crime or public corruption or another predicate worthy of consideration, such as investigations into police misconduct. Third, there are specific requirements in place and predicates for the court to consider before releasing a report. Fourth, there are the statutes require that a special prosecutor be appointed. Fifth, more robust involvement of the court in initiating and supervising the proceedings. Sixth, the assignment of a judge to supervise the report process. Seventh, a date certain for beginning and concluding the grand jury's investigation. A right to counsel when the report is accessible, and just overall a more robust involvement of the courts in the process. And this legislation does not have, in its current form, does not have many of these protections. The other thing I'd like to bring to your attention, and I really think that this comes from, that is consistent with what our Supreme Court has said regarding the grand jury in Rhode Island being a constitutional body. So two things have happened since the last time we were together to talk about this legislation in 2019. My recollection is that this bill was not heard last year. I could be wrong about that. So two things that I provided the committee with earlier today that really warrant, I think, your consideration. The first is a report prepared by a task force in Pennsylvania appointed by the Pennsylvania Supreme Court after a series of abuses of its grand jury law. And that law specifically regarding the reporting provision that is part of this legislation that's before you tonight. And I gave you the whole report, in pertinent part, what the Pennsylvania Supreme Court task force said about on this issue of allowing reports like such that would be allowed by this legislation. They made two recommendations. First, they said that the Investigating Grand Jury Act should be amended to eliminate grand jury reports entirely. In the alternative, that the law should be amended to preclude a grand jury report from critically commenting on a named or otherwise identified individual unless the comment relates to charges filed against the individual or charges recommended against the individual in an accepted presentment. And it goes on to make other recommendations, but I wanted to talk about that one because, because of the abuses that went on in Pennsylvania. One of the ones that I think I spoke of in 2019 is one that I think is familiar to most of us, and that was regarding Coach Paterno. Coach Paterno's name was released in a grand jury report when he was not the target of the grand jury's investigation. Jerry Sandusky was. And while Coach Paterno may or may not have acted correctly, he certainly had his career and his legacy destroyed by the release of a report that had nothing to do with his own behavior in a criminal context. Secondly, the other thing that we have with us now that we didn't have back in 2019 was the Rhode Island Supreme Court's decision in the 38 Studios grand jury case. And what the court said, consistent with its other opinions regarding the grand jury, is that here's what the court said. We are constrained to answer the question in the negative. There is no inherent authority in the Superior Court to disclose grand jury materials beyond that which is permitted by the Superior Court rules of criminal procedure. And specifically, I think the court is talking about Rule 6, which talks about grand jury proceedings and the type of material that can be released and that which can't be released. So I guess what I'm saying is that, I'm a criminal lawyer. I've practiced criminal law for more than 40 years. I'm not a constitutional lawyer, although my practice does delve into constitutional matters periodically. But I think what the court is saying in clear and unequivocal terms in the 38 Studios case is that if we want to do something like what is contained in this legislation, it needs to be done by the court and not by the legislature. I say that respectfully, understanding that, we're always talking about separation of powers and how, everybody needs to stay in their lane, so to speak. But the release of the materials in the 38 Studios case, our court thinks clearly and unequivocally that this is a matter for the court to consider and not for the legislature. So with that, I'd be happy to answer any questions that you might have.
Are there any questions of Mike DeLauro? David? Okay. No questions from Mike DeLauro? I don't see. Oh, John Lombardi, Representative Lombardi.
Yeah. How are you, Mike, Mr. DeLauro? Thank you for your explanation. And that was my concern. You kind of answered at the end. Separation of powers. Are we would we be overstepping our bounds, you think, based on that Pennsylvania case? I think you stated it quite eloquently. I think Joe Paterno, I think everyone knew, or at least surmised that, somehow he was involved. Not that he was involved, but I think it cast aspersions on his legacy, and, people started to withdraw from him. So, so separation of powers. Could you maybe explain that a little further, please? Because that's what my concern is with this bill.
Yeah, sure, Rep. Well, thank you. Like I said, I'm not a constitutional lawyer, but I'm interested in these things because, so much of what we do is a matter of constitutional law. The Pennsylvania statute apparently was the subject of a number of abuses. The reporting part of it was the number of some abuses in Pennsylvania, and I think Coach Paterno's case was only one of them. That caused the Pennsylvania Supreme Court to put together this task force made up of criminal justice stakeholders, and they spent a great deal of time thinking about how, what changes needed to be made to the law in Pennsylvania. And this report, I made it available to you earlier today. It's available online too, but I emailed it to you so that you can take a look at it. And the recommendation that I'm talking about is recommendation number. I don't have it in front of me. Recommendations Roman numeral 5, which is grand jury reports, and they make a series of recommendations about the grand jury reporting provisions of Pennsylvania law. So that's the first thing. The second thing is that I changed my testimony a little bit from 2 years ago because I think we've gotten past this a little bit. The stuff that the legislature can speak to regarding the grand jury is really in the nature of ministerial type things. So, for example, when the grand jury gets convened and how it gets convened and where it sits, these type of things can be the subject of statutory law and are the subject of statutory law. But the kind of inner workings of the grand jury, I think, from what I've read, that our Supreme Court has said in very clear language that this is a matter for the court to do, whether it's via court decisions, which they have made decisions regarding the power of the grand jury in a number of different contexts, or via the court's rulemaking authority. So I know I've gone on a little longer than I've wanted to, but I hope that I've answered your question with what I've just said about Pennsylvania and about the Rhode Island Supreme Court.
Yeah, Mr. Chair, if I may, I get concerned when another body with separation of powers, comes in and reaches in and says, okay, I'm gonna review this, and I'm gonna do this, and I'm gonna do that. And that's not exactly what's happening, but it kind of is. And people's reputations, and they can go from being famous to being infamous. And Joe Paterno is certainly a classic example. I mean, obviously these are heinous crimes, and you wish someone had stepped up at some point. But yeah, I mean, it's just you can start to assume certain things. And, this person was involved, that person was involved, and we're all friends. So if they mention two of the three stooges, they're going to figure out that I'm the third stooge. If you get what I'm trying to say, and if I did nothing wrong, what kind of an impact does it have on my life, my family, my business, and everything else? That's just my concern with this. That's all. Thank you, Mr. DeLonge.
If I could just respond very briefly, Mr. Chairman.
Sure.
Let me make absolutely clear that I don't know anyone in the current administration or prior administrations of the Attorney General's office that would do any of the things that were done in Pennsylvania. I've known dozens of Assistant Attorney Generals, including yourself, Mr. Chairman, many years ago, who presented cases to the grand jury and did so in very fair and open ways. And I remember one of the things that we stopped putting in our legislation about allowing or requiring that exculpatory evidence be submitted to the grand jury. The reason we did that was because the Attorney General's office, and I think it was Attorney General Lynch at the time, adopted a policy that mirrored the policy of the U.S. Attorney's Office regarding what ought to be done with exculpatory evidence in grand jury proceedings. So I just want to make it clear, and this is not, I'm not casting aspersions, but Mr. Norona and his folks aren't going to be there forever, and we're not. I mean, I hope they're there for a long time, but they're not going to be there forever, and you don't know what's going to come afterwards. And if you leave something in place that could be the subject of abuse, chances are pretty good it is going to get abused. And we have to keep in mind the grand jury is an incredibly powerful institution and ought to be. And so I think we need to be careful before we, make drastic changes like this.
Representative Knight.
Mike, can you talk to the idea that, as I read the bill, it seems to me that the power to issue the report always lies with the court. It just provides a more robust procedure for asking for the court to release the information than is currently in the rules of criminal procedure. But even as I look at the rules of criminal procedure right now, I have them up on my screen. These rules do allow for disclosure to be made when the court says it's okay. So, I already have a disclosure rule that's available today, right now as we speak. This bill seems to flesh that out a little bit, but leaves the power with the court. Does that change your mind at all on the separation of powers issue?
No, it doesn't, because the issue of grand jury secrecy is something that has been memorialized or codified in court rules and practices. And some of the cases that I looked at regarding grand jury procedures, some of them predate the adoption of the rules of criminal procedure, including Rule 6, back in the 1970s. So, that's why I think the Supreme Court is saying that this, Rhode Island has a common law grand jury, meaning it isn't a creature of statute, it's a creature of the court. And, of course, the Attorney General runs it, which, means that and uses the investigative powers. But, you'll recall the cases from years ago where the grand jury's authority to issue subpoenas was abused, and some of the other issues that have come up. So I'm not at all comforted by a major change like this that enhances even further the grand jury's power without providing enough protections. And I mentioned some of the ones that I researched when I saw, when I looked at other states and what they had. And I think the Pennsylvania experience is very telling. Their report says, don't do what, this legislation asks you guys to do. So,
Thanks,
hope I've
Mike.
answered your question.
Thank you, Michael. Any further questions of Mike DeLauro? Seeing none, that concludes testimony on House Bill. Oh, I'm sorry, David.
I did have a general question.
Sure.
In Rhode Island, how many members do we normally see on a grand jury?
Well, that's a good question. I know you need. I know the chairman's going to correct me if I'm wrong. I think you need 13 to get an indictment.
Between 13 and 23.
It's when they seat a grand jury, they seat it with its maximum number. It's 23, but you need 13 to indict.
So to return a true bill, you need 13 to indict.
Correct.
All right. And this law is saying that you need 12 in order to request the issuance of a report.
Correct.
That's why I'm reading it. Okay. I wanted to wait till the testimony was complete before I commented on this. I don't know. I don't like the legislation. Mike DeLauro had some pretty good comments about separation of powers I didn't think about, but the grand jury is not just an institution in our criminal justice system, but if it's not the keystone, it's a cornerstone. And I think when you start playing around with centuries of tradition for exceptional events, and when I mean exceptional, you're talking maybe something that might happen every 10 years or so, you're playing with trouble when you start to do that. After doing my research in this bill, you go back to some of the Supreme Court decisions, the key thing that jumps out at me is the comment, if I'm a witness before a grand jury, right now I know whatever I say isn't going to get out. I know that I have faith in that. But if there's a chance that my testimony may get out, I might question, one, whether I want to show up for it. I mean, granted, I could be subpoenaed to it, but two, when I get there, am I actually going to tell the truth? If I know there's a chance what I have to say about a person is going to get out, do I really want to put myself in that position? And I don't know if we want to go ahead and start again tinkering with, I think I found something like 800 plus years of tradition with the secrecy of the grand jury. And I just don't believe it's a good idea to start messing around with that kind of thing right now.
Thank you, David. If there's no other questions of Mike DeLauro, then we would conclude testimony on House Bill 5858 and move on to Chairwoman Fogarty's bill, House Bill 5987. And I will introduce it as it's an act related to public utilities and carriers, the Rhode Island Public Transit Authority. It limits damages to $100,000 in any tort action against the Rhode Island Public Transit Authority, except in cases where the General Assembly, by a special act, authorizes a tort action in excess of that amount. Chairwoman Fogarty.
Thank you, Chairman. I think you pretty much read most of the bill. It's not a very long bill, but the point of the bill is that this $100,000 would provide RIPTA with the same type of financial protections that the other against suits that other state and municipalities already enjoy. I understand that when the courts first ruled about RIPTA as being a quasi-state agency, it did not receive the protections as a state. It was because of its operation as its primary proprietary function for the government was to just really have a private business operating a bus service throughout the state. However, over the 30-plus years that RIPTA has been in service, it's now clear that it would be impossible for an entity to serve the people of Rhode Island without substantial government support. And now that as we're trying to encourage people to take the buses, to stop pollution, take more public transportation, we really must make RIPTA financially secure. RIPTA is not a regular government agency, but when its finances are diminished, the state would find ways to make up for these shortfalls. And I just want to be clear that this is not intended to absolve RIPTA for any wrongdoings, but to limit it as a target for people who see it as a place to, as a cash cow or a place that has deep pockets to pay off any claims that are made against it. If we lose RIPTA through some type of a huge lawsuit, then we have no public transportation for the state. And that's why I got involved with this bill. It's a concern. If something happened to a RIPTA bus and it went off a bridge somewhere and it had, it was packed with people, the amount of litigation would probably put RIPTA out of business. And so I think that they're just trying to look for some more protections to make sure that RIPTA is not going to go anywhere in case there's a major problem. So that's why the impetus of the bill. So I appreciate your time, and I'll take any questions.
Any questions of the sponsor? Yes, Representative McAtee.
If you can answer this, Kathy, how are they insured? Are they self-insured? Do you have any idea?
I believe that they're self-insured because they're not under, any protection. Yes, they have their own insurance.
Representative Norrie.
Thank you, Chairman. I guess my question, Kathy, is for you, but maybe a lawyer in the room. Are we talking about any damages recovered in like one incident? So there's 15 people on a bus, 15 people get hurt. Is it $100,000 total, or is it going to be $100,000 times 15?
I believe at this point it would be $100,000 total for
If it was 15 separate acts of negligence with injuries, they would be 15
there you go. That's my lawyer.
cases.
Perfect. Thank you.
And you want to know what 1/3 of that is? Because I can give you that number right away, too.
I can even help you with that one.
Or 44% if you go to the wrong person. So.
So again, it's just really trying to protect RIPTA, because if we lose RIPTA, if there's a major accident, we have no transportation, and
Yep.
that's the only transportation that people have. This whole thing of it being a quasi-agency is really a problem for them. So
Understood. Thank you.
thank you.
Thank you. If there are no other questions of the sponsor, Representative Fogarty or Chairwoman Fogarty, that was a great bill, something that I didn't know existed, so I appreciate that. Thank you. The next bill is House Bill 5580, sponsored by Deputy Speaker Lima. It's an act related to domestic relations, divorce, and separation. It creates a custody procedure for pets in divorce and separation proceedings based on the best interests of the animal. This act would not apply rather to assistance or service dogs. Do we have Deputy Speaker Lima on the phone? We do?
I gotta go check into labor.
Yeah. While we are waiting to locate Deputy Speaker Lima, John, Manny, if I could prevail upon you for a minute. I believe I had a question posed to me by Judge Fort, the Chief Justice of the Rhode Island Family Court today, in reference to a single word used in this bill the word is custody. Could you tell me what you found out?
Using the same language for an animal or pets which are deemed property in the family court for purposes of distribution of assets or divorce. So we have some concerns as the term is used throughout the bill, sort of interchangeably, custody and possession, and perhaps his concern what he'd like to see with possession as opposed to custody.
Thank you very much. Any questions of John? Okay. Oh, yes. Representative Vella Wilkinson, I see you in the upper left-hand corner. Would you like to be recorded as being here and have your votes recorded? You're still muted, I think. You have to.
Yes, thank you, Mr. Chairman. I appreciate that.
Thank you very much. Thanks for coming. Okay. Okay, well then that will conclude testimony on House Bill 5580, which brings me to the next bill sponsored by Representative Diaz. It's an act related to criminal offenses and particularly children. And it raises the legal age for persons to purchase or be sold or delivered certain tobacco products, electronic nicotine delivery systems, and liquid nicotine containers, raising the age from 18 to the age of 21 years old. Do we have this? Okay. Representative Diaz, if you could unmute yourself. I see that you're still muted. You're like me, I don't know which button to push either. Oh, there you go. All right, we can hear you now.
Good evening.
Oh, that's something.
Are you hearing me okay? Because it's echo.
Do you have a speaker on? I'm being told that.
But I have some echo. I don't know why.
Okay. All right, you can proceed. We'll figure it out.
Okay, thank you. It's difficult. Chairman Graven.
Yeah. If that's troubling, do you want to put you on hold for a second and take some of the witnesses and see if I can have the tech people figure it out?
Yes, please.
Could you call in by phone? Could we call you by phone?
Yes.
Okay, that's what we'll do. Thank you. Yes, Sean Palumbo? Mr. Palumbo? Sean? Sean Palumbo?
Yes.
You're on the air to testify on Representative Diaz's bill. You can proceed.
Oh, thank you. All right. Hello and good evening. My name is Sean Palumbo. I'm from Bristol and currently a freshman at the Community College of Rhode Island, and I'm studying political science. I'm here tonight in support, here over the phone tonight, in support of this legislation. Why, you ask? Well, looking back at the past 4 years of high school, during the rise of vaping, I've had many conversations with my friends and peers about vaping. Some of these conversations were with those who have quit vaping or quit smoking traditional cigarettes, and some were not. My biggest takeaway is the realization that many of my friends were addicted to nicotine, something I never thought would happen to them. Most of my friends, they talked about how they wanted to hop on a trend and wanted to vape like some of their friends. After they started, they were finding themselves searching and looking for ways to obtain e-cigarettes, even at the risk of being caught in possession. They never felt like they had a choice because they were addicted. This bill is extremely important, not only to me, but also my peers. We need to have this legislation enacted as written to stop and prevent future use of these addicting products that also have extremely high concentrations of nicotine and come in fruit and candy flavors, which are very attractive to people my age. Sorry, excuse me. I believe we should not penalize addiction, but instead we should increase the penalties on retailers who keep repeatedly selling cigarettes, e-cigarettes, and other tobacco products to underage youth, and they only receive a slap on the wrist. It's important that we're able to provide adequate and appropriate enforcement to prevent retailers from selling to those who have not yet reached the age of what is being proposed. That's about it for me. So I just want to say thank you for this opportunity to come on the phone and testify with you tonight. And then I hope this legislation passes and that we as a state, that we can start to take the next steps to becoming the next tobacco-free generation.
Thank you, Sean. Any questions for the witness? Seeing none, the next witness is Daniel Fitzgerald. Oh, you do? Yes, please. She's the sponsor.
The Judiciary Committee.
Thank you.
My apologies for the inconvenience. We still have this feedback.
Yeah, I can hear it.
But let me turn my computer off.
Okay.
Is much better now?
Yes, that's great.
Okay, thank you so much. And again, my apologies for the inconvenience. Thank you for the gentleman who testified before me. My explanation to the bill is that the bill will update the state statute to align with the federal Tobacco 21 law that raised the minimum legal sales age for all tobacco products. As you read the bill at the beginning of this hearing, the bill listing all the tobacco products, including electronic cigarettes, to 21. The bill also will ensure adequate and appropriate enforcement of Tobacco 21 in Rhode Island by revising two sections of the existing law. One is restoring judiciary discretion over the license suspension. Right now, as it is, the court has no choice but to suspend the imposition of a license suspension. If the license holder can demonstrate that they trained employees and took steps to prevent the sale of tobacco products to underage individuals, the court has the discretion to decide about the suspension of the license. Another great aspect of this legislation is when the existing law talking about penalize for the sales of tobacco underage. For this legislation, we now impose those penalties to the users, is to the tobacco industry, which using all tactics to deflect and blame for retailers and the industry predatory marketing practices. In the bill, we really improve the law in Rhode Island and again align with the federal law for tobacco 21. Thank you for your attention, and I hope we can raise the access to tobacco products to the 21, which is so important in the state of Rhode Island. Thank you.
Thank you, Representative Diaz. Any questions for the sponsor?
Chairman Craven, this is Julie. I have a question for you.
Yes, Julie.
I had a vaping bill heard on Monday that is very similar to this. Why was it heard in Health and Human Services and this one is heard in Judiciary?
I'm sure that's a third floor decision that probably made by the Speaker's chief legal counsel.
Okay, thank you.
It's possible, Julie, that it had something to do with this changing the law as it relates to tobacco usage, and the other may have been just, I don't know, modifications of the uses of the vaping product.
Okay, thank you.
Daniel Fitzgerald? Daniel?
Hi, yes.
Hi, Daniel. You're on the air testifying on the bill. You may proceed.
Wonderful. Well, good evening, Chairperson Craven and members of the House Committee on Judiciary. My name is Daniel Fitzgerald. I work for the American Lung Association as our National Senior Manager of Advocacy and serve as one of our advocacy leads here in the state of Rhode Island. On behalf of the American Lung Association, I really appreciate the opportunity to testify tonight alongside our partners in support of House Bill 5571, which, as sponsor mentioned, would update state statute to parallel that of the federal law that passed in December of 2019 that raised the minimum legal sales age for all tobacco products, including electronic cigarettes, from 18 to 21. The increased tobacco sale age has been the law of the land for well over a year now. However, we have not armed our state with the measures that allow it to be adequately and appropriately enforced. We also know that tobacco use is not only a public health issue, but it's also a social justice issue. Currently, state statute penalizes, victimizes, and stigmatizes youth for the use and or possession of any tobacco product. House Bill 5571 repeals those youth use and possession provisions and restores judicial discretion over license suspensions for repeat offenders. If you're interested in any additional information, I would just point you to the joint testimony that we provided alongside nearly 20 other local medical and public health organizations. And finally, I would just like to say thank you to Representative Diaz for introducing this bill. Thank you for all of the sponsors, and thank you to each of you here, members of this committee, for your dedication to protecting our youth and young adults here in Rhode Island from a lifetime of addiction and disease. Thank you.
Thank you very much, Daniel. Any questions for Daniel Fitzgerald? I do not see any. Next witness is Megan Tucker. Megan?
Yes.
Can you hear me? You're on the air and you're free to begin your testimony.
Great. Thank you, Chairman Craven and members of the committee. My name is Megan Tucker, and I'm with the American Heart Association. And we would like to voice strong support for House Bill 5571, and we thank Rep. Diaz for her leadership. I will be very brief because I think Rep. Diaz and my colleague Dan Fitzgerald covered all of the points that I was going to make. But as you heard, Tobacco 21 is the law of the land, and this bill is really needed to align our state statute with the federal Tobacco 21 law. We also agree that we need to ensure adequate and appropriate enforcement of Tobacco 21 by repealing the youth possession, use, and purchase penalties currently in state law these types of provisions are ineffective and inequitably enforced against youth of color. And as you've heard, these provisions also stigmatize youth when they are the victims in all of this, falling prey to the industry's flashy marketing and social media. Addiction should never be punished. We want youth to get the help that they need. And then secondly, the bill would restore judicial discretion over license suspensions. If a retailer is a habitual offender who repeatedly sells to youth and is before the courts, 3, 6, 8 times, clearly there's a problem, and the courts should have discretion to hold retailers accountable and suspend their license when corrective action is needed. So thank you so much for your time. We hope that the committee will recommend passage of this bill.
Thank you very much, Megan. Are there any questions of Megan Tucker? Seeing none, next witness is Gregory Conley. Gregory, you are on the air and free to testify.
Thank you, sir. Chair and members of the committee, my name is Gregory Conley, and I currently run a nonprofit 501c4 organization called the American Vaping Association, which advocates for sensible regulatory policy in order to maximize the number of legal adults that use nicotine vaping products to get off of smoking cigarettes and reduce their harm through a practice known as tobacco harm reduction. And while we have some quibbles with some of the language in H5571, we are nonetheless here tonight to be generally supportive of the bill. We had been recommending that Rhode Island take the step of moving towards Tobacco 21 since 2019, when then Governor Raimondo took advantage of lung illnesses that were being caused by illicit THC products to end up banning the sale through administrative rules, flavored vaping products all throughout the state of Rhode Island on the legal market. Of course, black market sellers have stepped in to fill that role. But the stories you're hearing tonight regarding vaping products, it's important to keep in mind, the last 18 months, there have not been legal sales of flavored vaping products in Rhode Island. We've seen, prior to the pandemic, the National Youth Tobacco Survey from 2019 to 2020 nationwide, there was about a 30% decline in youth vaping. And a survey that was taken in the middle of the pandemic suggested that with even fewer social sources, use may have dropped by another third. So Tobacco 21 at the federal level absolutely has worked. So it remains to be seen exactly how much, but a 30% decline in 1 year is certainly notable. There are 2 points that I'd like you to consider. The language in this bill, even though you don't really need it to raise the age to 21, you are making, quote-unquote, electronic nicotine delivery systems a tobacco product. Well, the definition is so broad, and it's good to have good, broad definitions to keep products out of the hands of minors. But your broad definition is going to make CBD vaping products and nicotine-free vaping products tobacco products. Why can't they just be continued to be under the electronic nicotine delivery systems category, which already has a retailer license? Second point, internet sales. There was a new federal law very strictly regulating internet sales. Rhode Island's existing law that you're amending is very close to federal law, but it may make sense to just clean up the code and use the federal law so you have simplicity and you have no one that can claim they did not know the law. And so in closing, with 21 becoming the law and is the law at the federal level, it makes sense to do this at the state level. FDA is going to be regulating these products on the basis of whether each individual product is appropriate for the protection of public health. We also encourage anyone listening, Rep. Casimiro has an excellent bill that, in combination with Tobacco 21, I think is a very smart regulatory approach. Thank you very much, and appreciate it.
Thank you very much. David Place, you have a Representative Place, you have a question?
Yes. Sir, you mentioned in your, are you still there?
Yes, I am.
All right, cool. During your statement, you had mentioned some reduction statistics during the pandemic. I was just wondering, are those statistics based off of surveys, or is that off of sales information?
Sure. So the first survey, the National Youth Tobacco Survey, that was done pre-pandemic. That was about a 30% decline from 2019 to 2020. The second survey was done by independent researchers not associated with the tobacco industry. It's not as high-powered of a study as the National Youth Tobacco Survey that's funded by the federal government, but nonetheless a positive result from anti-tobacco researchers, and I'd be glad to send over that study to the committee.
Just curious, with the 30% between the first study, did you account in any way for the possibility that, people just aren't going to answer because the stigmatism that had started to be associated with these products?
So the NYTS and all of these surveys are done anonymously. They're done in ways that they can catch whether people are just filling in blank boxes rather than paying attention to the survey questions. We pretty much rely on the NYTS as well as the Monitoring the Future data for surveys about teen opioid use, teen marijuana use, teen alcohol use, all of this. So it seems doubtful that just 1 year you would end up with a big increase in the number of teens willing to lie on an anonymous survey about whether or not they vaped in the last 30 days. Hope that answers the question.
Okay, if there are no further questions, the next witness is Dr. Samuel Evans. Dr. Evans, you are on the air and free to testify.
Great. Thank you very much. Good evening to the members of the committee, and thank you for taking your time and doing this very important work. And it really is my pleasure to speak briefly to you all, even in this sort of virtual format. My name is Dr. Samuel K. Evans, and I'm a board-certified pulmonologist and critical care physician and faculty at Brown. And I'm speaking on behalf of the Rhode Island Thoracic Society, as well as the Rhode Island Medical Society, in strong support tonight of House Bill 5571. I'm very sort of proud to support these key legislative efforts. This one brought forward by Representative Diaz, to which we really should all be grateful for bringing very sensible, very forward-thinking and evidence-based measures to a problem that we all face as providers on a day-to-day basis, and that's all before COVID. The nuts and bolts of what I think is before you this evening, and which I hope will make it out of committee for a vote, is to do two things: is to restore judicial discretion over license suspensions, and to essentially decriminalize addiction, and realize that addiction should not be punished; it should be treated. And I think that's common sense, and I think we're starting to understand that as a society better. Rhode Island has done very well over the years with progressive tobacco policy, and it has been on a number of fronts. And I really encourage the committee to keep that fight going, because keeping kids from getting addicted in that very vulnerable state that they're in is really one of our strongest tools to improving the health of our community. If we can keep kids from getting hooked, then we can keep kids from smoking and then getting sick with the ravages of COPD, of lung cancer, and many other diseases that I and my colleagues take care of every day. And my last bit of this is that the healthcare providers in the state were working very hard throughout this pandemic, and we really need wins on every front that we can. All right, and we're still taking care of all the lung diseases in addition to COVID. And Rhode Island has done great and with tobacco control policy, and we really want to see this forwarded. So I strongly support House Bill 5571 as a member of the Rhode Island Thoracic Society, the Rhode Island Medical Society, and as a practicing doctor on the front lines. And I thank you all very much. If anybody has any questions, I'm happy to take any at any point. Thank you so much for your time and consideration. Good evening.
Dr. Evans, thank you very much for your testimony. I don't see any hands up, so I don't think there's any questions, but I would like to take a moment to say you got a tough job, and you've had a really tough job the last year. And for that, you're a frontliner, and we owe you a debt of gratitude. Thank you.
Thank you so much, Chris. Have a good evening, all.
Take care. The next witness is Katie Arona. Katie, you are on the air, and you're free to go ahead with your testimony.
Hi, you guys can hear me okay?
Yes, we can.
Okay, great. Thank you for having me. My name is Katie Arona, and I'm the health policy analyst at Rhode Island Kids Count. And I'm here today to offer our organization's very strong support for House Bill 5571, and would like to thank Representative Diaz for her leadership on this issue year after year. As you may know, Rhode Island Kids Count has been tracking youth who report using tobacco as well as nicotine products for many years. And although we have seen tremendous progress being made to decrease youth cigarette use in the previous decade, youth use of electronic cigarettes has unfortunately recently rapidly increased, so much to the point that in 2018, the U.S. Surgeon General declared the use of e-cigarettes among youth an epidemic in the United States. Specifically, we know that electronic vapor products are one of the most popular emerging products being used by youth. The latest data that we have for Rhode Island in 2019 shows that 49% of high school students reported ever using an electronic vapor product, and almost 1 in 3, 30%, reported current use in the past 30 days. Similarly, 16% of the state's middle school students reported ever using an electronic vapor product, and 7% reported current use during that time period as well. And evidence shows that although e-cigarettes do pose less risk to an individual than traditional combustible cigarettes, these e-cigarettes are still harmful to youth, given that they contain nicotine, which we know is a highly addictive chemical that can severely harm brain development, which continues to the teens and into the early to mid-20s. This bill has been supported, or the idea of having a tobacco to 21 bill is supported by many national organizations with strong reputations, including the American Academy of Pediatrics, as well as the Institute of Medicine. They both recommend increasing the minimum sale age to 21 to delay access and initiation among youth. And so for all of those reasons, we would urge you to pass this bill, and we thank you for the opportunity to testify today. I'm happy to take any questions if there are any.
Thank you very much. Any questions for the witness? Seeing none, that concludes testimony on House Bill 5571, which takes us to Representative Lombardi's bill, House Bill 5569. It is an act related to domestic relations, domestic abuse prevention. It permits the family court to award custody of household pets to the plaintiff in a domestic abuse complaint.
Thank you, Mr. Chairman, members of the committee. I'll try and go quickly. This act would basically permit the family court to award custody of household pets to plaintiffs in a domestic abuse complaint. What this does, Mr. Chairman, members of the committee, if you look on the statute itself, page 2, it gives a definition. Number 6, household pet means a domesticated or tamed animal kept for companionship or pleasure. And then on page 3, subsection 4, awarding the plaintiff custody of the household pets, if any, including the enforcement remedy of the restraining order or other injunctive relief is necessary. And I would point you to a letter that was sent by the American Kennel Club that I think states it very clearly. The health and well-being of animals and preserving each unique breed. And then it talks about, protection orders. And, when this sometimes feuding couples will, put children in the middle. If there's not children, then they'll put their pets. And what this does is creates a protective order. And then, because what happens is far too often victims of domestic abuse are reluctant to leave dangerous situations for fear or fate of the pet left behind, which is scary. But and I've done enough divorces. I'm sure some of the other lawyers that are on the committee have done enough divorces where the issue of pets becomes very contentious, and you just can't believe. And they're really treated like they're children. So I think it's an important amendment, an important addition to that statute, 1515-1, and I will endeavor to answer questions if I may. Thank you, Mr. Chair, members of the committee, for your time.
Thank you, Representative Lombardi. Any questions of the sponsor? Seeing none. Oh, I'm sorry, Edith Agello. Yes.
Thank you, Mr. Chairman. Perhaps it's a question for the Council Manny.
Sure.
This legislation speaks of custody of pets, and I believe earlier today Mr. Manny was talking about the courts being concerned about the word custody being used with reference to pets.
That's correct, Representative. The Chief Judge of the Family Court has an issue or concern relative to that.
term custody as it relates to family court and in family court actions because of the case law and the statutory, the statutes that are in play right now relative to divorce. There are some additional language or other language that could be used, perhaps possession or ownership. In fact, there's another bill Rep. O'Brien, I believe, has on tonight that speaks similar to this and uses the term ownership, I believe. So that is a concern.
Thank you.
Thank you.
Any other questions?
I assume the sponsor would be fine with that change.
No problem. We want to comply with the case law and the Constitution.
Any other questions of the sponsor?
Thank you, Mr. Chairman, members of the committee.
Thank you, John. That concludes testimony on House Bill 5569, which takes us to Representative Agello's Bill 5570. It's the Solemnization of Marriage Bill. It's an act related to domestic relations, specifically solemnization of marriages, and it requires return of a marriage certificate to be filed within 2 business days after the ceremony and would validate the common practice of filing the return by mail.
Thank you, Chairman Craven. This idea for this legislation was brought to me by a constituent who is a municipal court judge and performs marriages. And she, it was pre-election a couple years ago, and she had performed a marriage on the Friday evening of Columbus weekend. Our current law requires that the marriage license be returned completed to the licensing office within 72 hours of the marriage taking place. If the wedding was taking place on Friday evening of a 3-day weekend, it would be impossible to get into the license office in the city of Providence, or I think any other city or town in Rhode Island. So this legislation would change that 72 hours to 2 business days, so that the wedding on Friday evening, the license could be turned in on Tuesday or Wednesday of the following week. What I also found out, actually, legal counsel David Duma did some research on this and found that most of the license offices in the state are now accepting marriage licenses when they're mailed in. So this would recognize that and make that legal also. So very simple, really. Solves a problem that maybe doesn't really need to be solved since people are working around it, but we ought to have the law match what's happening, I think.
Great. Any questions of the sponsor? All right, there are no witnesses signed up, so that would conclude testimony on House Bill 5570, which brings us to Representative Felix's bill, which is an act related to, it's 5988. It's an act related to courts and civil procedure. Procedure generally, it's liens against causes of action. And it specifically says that it prohibits a hospital from claiming a lien on any damages recovered by a Medicaid patient as a result of an accident not covered by workers' comp. The floor is yours.
Thank you, Mr. Chairman. Hi, members of the committee. As the chairman has explained, this bill is very straightforward. Basically, it's a bill about fairness. As it works right now under current law, a hospital can put a lien on a person's property in order to get payment, or they can go through the Medicaid. And basically what we're trying to do is to prevent liens from being put on person's property, especially this is a difficult time going through any type of procedure or medical issues. So we want to make sure that folks who are on Medicare, they're already maybe already low income, are protected. We do have 2 witnesses, I believe, who signed up to testify who have a lot more knowledge and information than I do about this issue. So I would hope that you can direct any questions to them who are better prepared to answer them. And thank you so much.
Great job. Thank you. Any questions of the sponsor? Okay, then we'll go to the first witness, Tony Leone from the Rhode Island Association for Justice. Anthony.
Yes.
You are on the air. Bob Craven. Ready to roll.
Hi. Thank you.
You're welcome.
Good evening. Good evening. Thank you for allowing me to testify tonight. My name is Anthony Leone. I am a member of the Rhode Island Association for Justice and a past president of our organization. I'm here to speak in favor of amending Rhode Island General Law 9-3-4. Amending the hospital lien statute seeks to achieve a fundamental fairness, particularly for Medicaid recipients who may not have an attorney or may not be pursuing a case when they are hurt. If a person has health insurance like Medicaid, the insurer should be billed like any other health insurance. The purpose of the hospital lien statute is for hospitals to be fairly reimbursed when someone is hurt. Health insurance, including Medicaid, remains a primary payment method for hospitals when someone is injured through no fault of their own. Hospital liens, claims, and reimbursements should be tied to the available insurance, including Medicaid. Amending the statute requiring hospitals to pursue Medicaid or other health insurance reimbursement serves justice and fairness for all injured people. Thank you for the opportunity to speak, and if there are any questions, I'd be happy to answer them.
Any questions for Anthony Leone? Thank you, Anthony. The next witness is Anthony DeSisto, also from the Rhode Island Association for Justice. Tony.
Yes.
You are on the air. Bob Craven, good to hear you.
Thanks for Chairman Craven. I appreciate it. I'm speaking for the Rhode Island Association for Justice here, Anthony DeSisto, and I have to say that I applaud Representative Felix for putting this in. It's really on the cutting edge. 4 states have enacted this type of legislation, and I understand that in Vermont they are also considering this legislation too. I agree with Mr. Leone and Representative Felix that this is a matter of fairness, and in matters of this nature, if there is Medicaid available, that should be the avenue of compensation. I'd be happy to answer any questions you may have.
Any questions of Tony DeSisto? All right, seeing none, that is the end of the witnesses. If we could keep them online, Chris, because Anthony or Tony is going to be testifying on the next 3 bills as well. So
thank you, Mr. Chairman.
Yeah, you're welcome. Hang on, Tony. We'll get to you by introducing the next bill and taking this one out of play right now. That concludes testimony on a great bill by Representative Felix. Brings me to the next bill, which is 5867, sponsored by myself. It's an act related to courts and civil procedure, causes of action particularly, and a product's liability defense of subsequent alteration would be eliminated. The floor is yours, Anthony.
Thank you, Mr. Chairman. Again, it's Anthony DeSisto for the Rhode Island Association for Justice. Rhode Island law currently grants a manufacturer of a defective product complete immunity from claims by an injured person if the product has been altered or modified since the product was sold. And, the current definition, the statutory definition of a subsequent alteration or modification is extraordinarily broad. That was adopted in 1978 and has never been amended. At the time, it was one of the strictest standards that was enacted. In the 43 years since its adoption, this law has become an outlier. And right now, because of this, Rhode Island is one of the most regressive states for product liability cases. And I only bring this up because this is another question of fairness. If a product has been altered after the sale. That should be something for the jury to decide as to whether or not that alteration has so changed the product that there is no liability. Perhaps it was such a minor modification that it wouldn't even account for the product defect. This is a fairness thing. People get hurt from products all the time. I'm not going to go through the recitation of all of the cases that have been had for these products that were unsafe. But in this instance, to me, it's a question for the jury to decide, as opposed to granting complete immunity to the manufacturer. Mr. Chairman, if you have any questions or any members of the committee, I'd be happy to answer them.
Any questions of Tony DeSisto? All right, Tone, thanks. We're going to move on to, that ends the testimony on my bill, 5867, and we'll go on to Representative Noray's bill, which is House Bill 5581. It's an act related to court civil procedure, particularly actions in the death of another, of creating a wrongful death action. And it allows recovery for damages for the emotional distress, grief, and loss of enjoyment of life as a result of the wrongful death of a spouse, a parent, or a son or daughter. Representative Noray.
Chairman, thank you. As always, you described most of the bill, so I'm going to just let you know that 23 states and Puerto Rico currently allow a survivor to recover emotional pain and suffering damages for death of a loved one. This proposed amendment does not allow for these damages as a matter of right. It simply allows the jury the opportunity to consider compensation for this suffering. The way the law stands now, a spouse is allowed to seek recovery only for the general loss of the relationship with their husband or wife. Presently, a spouse is not allowed to seek justice for emotional distress, pain and suffering, and loss of enjoyment of life that accompanies such a loss. I think it's a great bill. Thank you.
Good bill. Very good bill. Any questions of the sponsor? Seeing none, Tony, you're back up again.
Thank you, Mr. Chairman. But I have to say that both you and Representative Noray have made all the points that I was going to make. So you make my job a little bit easier tonight. Of course, I agree with the statements that were made. That's exactly what the bill does. And it allows for spouses as well as others to collect this damages. I think it's a great bill. I'm very happy that Representative Noray put it in, and if there's any questions, I'd be happy to answer them.
Any questions of Anthony DeSisto? Okay, that concludes testimony on House Bill 5581, which brings us to the last bill of Tony DeSisto, the representative from the Rhode Island Association for Justice, has before us tonight. This is sponsored by Chairwoman McEntee. It's an act related to courts and civil procedures, particular actions, and it particularly talks about the contribution amongst joint tortfeasors. And if I can read the explanation. You can read the explanation. You go ahead. Fire away.
This act would repeal the section of the law which provides that a joint tortfeasor receives the greater benefit of the sum paid by a released tortfeasor or the percentage of fault attributed to the released tortfeasor. If anybody can make sense of that, I don't know. I'd have to read it 5 times. But this act would limit the credit received by a joint tortfeasor to the amount paid by the released tortfeasor without regard to funding of fault. Is that right? Funding of fault?
Yep.
The act would take effect upon passage and would apply to all claims pending at the time of passage or asserted thereafter, provided, however, that this act would not apply to, affect, or impair releases executed before the passage date. So, Tony, I hope you're on to explain all this, because I believe I was asked to put this in by the trial attorneys. Am I right on that, or was it your group?
Yes. It's actually that is my group, the Rhode Island Association for Justice. is the Trial Lawyers Association, essentially.
I do believe it's a good bill. I want you to know that. That explanation that I just gave, I know there's a much better one that you can give. So it's all yours.
But may I go to it, Madam Vice Chair?
Of course you may.
Okay. Currently, if there are multiple defendants in a case of this nature, the set-off is not dollar for dollar for the settling defendant. So in other words, if you have, say, 3 defendants or 5 defendants, if one of the defendants is willing to settle and the plaintiff is willing to take it, you really can't do that because the set-off isn't on a dollar for dollar set-off on the total claim. Rather, what happens is it's on a percentage of fault. So what that essentially does is it makes it so that all of the defendants have to stay in until the case concludes. And this is something that the General Assembly has addressed in several cases over the past few years. For instance, the St. Joseph's case with the pension, with the 38 Studios case. The General Assembly passed bills affecting the one case. The last one, which you did, I think, 2 years ago, was the Ringling Brothers case when those performers were all injured in one of the performances right here in Providence. So at the time when that bill passed, there wasn't much opposition. But what was said was, look, if we're going to do it here, why don't we do this for all cases? And, that's a good point, and that's the reason that the bill was put in, and that's why we thank Vice Chair McEntee for putting this in. That's correct. If it's okay for those cases, it should be okay for all cases. Basically, what this case will do is bring Rhode Island in line with the majority of other states that allow for dollar set-offs when there are multiple defendants. It will encourage settlement, and it will reduce the ultimate cost of these types of cases. That's why we think it's a good bill. We're hopeful that it passes, and if you have any questions, I'd be happy to answer them.
Any questions for Tony? Yes.
I just wanted to mention another thing, Tony. Like I had a case where we had one party was like, I think it was a 90% responsible, and the other party was like 10%. And we had the settlement that we wanted, but we were going to have to try it on the remainder. And so I do understand how this is a good bill. So I just want to let you know that. The explanation was tough for me at the bottom of the bill, but. So what you're saying is you can settle against one tortfeasor and you can either continue on the other one or do you have to release the other one as well? That's what I want to know.
No, what would happen is that defendants can settle out individually. The plaintiff can accept those settlements because it would be a dollar for dollar set-off and it wouldn't impair the rest of the case. So it encourages settlement.
But the way it is now, I mean, you actually get to pressure the lesser tortfeasor into settling because they certainly don't want to go to trial. I mean, I'm just saying that's sometimes it works that way, as you know.
Yeah, what happens, I think, with the current law is, the plaintiff is put in that difficult position, and basically what they do is they have to keep all the defendants in and not take any settlements until you have a global one or you go to trial.
Yeah, you can't settle on any. So, that is a problem. But anyway, thank you.
Thank you, Madam Vice Chair, and I agree with you. The explanation is a tongue twister.
Yeah, it is.
Thank you, Tony. I think that there's no other questions that I could see, and that concludes testimony on Vice Chair McEntee's bill.
Mr. Chairman, thank you very much.
You're welcome. Good to hear from you.
Take care now.
Representative Batista has come from yet another committee. I think this is the 9th one he's going through today. He's solved the budget problem, immigration. I think he's working on the Judiciary now, so welcome.
And got health care for everybody.
Yes, I know.
Thank you, Mr. Chairman. I'd like to ask that I be my president, obviously, and any vote to hold the bills in all committee. I was upstairs in labor, so thank you.
Thank you. Okay. The next bill is House Bill 5866, sponsored by Minority Leader Filippi. It's an act related to criminal procedure, pen registers, and trap and trace devices. This is an investigatory tool that the Attorney General uses in cases, as well as police departments. It prohibits the use of a stingray cell site simulator device by any law enforcement agency, except upon application for its use and the granting of an order by the presiding justice of the Superior Court. You have to apply for a pen register to the presiding justice of the Superior Court if you're a police department or the Attorney General. In this instance, it extends it now to the mechanism or the method used. It appears that Stingray cell site simulator is a device that you have to now ask to use as well. So we do have two witnesses that have signed up. The first is Gregory Waskmuski from Amnesty International. Gregory, can you hear me?
Yes. Can you hear me?
You are on the air and you're free to testify.
Thank you so much for having me. I'm truly honored to be here with you all tonight. I'm testifying in support of this pen register bill. I'm truly impressed. This is long overdue. I'm sure you've all heard how this bill is going to stand up for civil liberties. Protecting the civil liberties of the people in our state takes the entire village. I'm really looking forward to more bills coming through, especially from Representative Filippi, that make it harder for law enforcement to deploy intrusive, costly technology without justification and due process. For instance, facial recognition or UAV surveillance and so on. We really need to work hard on all fronts to protect in our state the First, Fourth, and 14th Amendment rights of all residents. So, with that, I'll just leave you with, as a member of Amnesty International looking at human rights, these are civil rights issues every single day. Again, really commend Representative Filippi for bringing a great piece of policy, and I'm hoping you will all support him and this bill passed onto the floor. Thank you so much for your time. Any questions?
Any questions of Greg? Seeing none, thank you, Greg. We have one more witness in this bill, Randall Rose. Hi, Randall.
Hello.
You're on the air. You can testify.
Okay, thank you. So it's important to have some regulation of stingrays because they are very intrusive devices. These are fake cell phone towers that basically appear to any cell phones in the vicinity as if they are as if they have the best connection of any cell phone in the area, but they are used to force cell phones to connect them, and some models of Stingray can also look at data that is stored on the phones. So they don't just capture phone conversations like a regular wiretap, but they even go beyond that, capturing data stored on the phones. But right now, we don't regulate them at all. And it just like wiretaps are supposed to require a court order, Stingrays should too. Right now, there's no regulation there's no law that requires the Stingray to be used only pursuant to a court-authorized investigation, and it should not be possible for government employees to capture to use these devices that capture hundreds or thousands of cell phones information when without even satisfying a judge that they have probable cause to investigate a single person. So this bill is definitely overdue. I do have some concerns about it. My primary concern about the way the bill is drafted, which I think could be made stronger, is this bill does not actually even require court authorization for a Stingray. It's creates a process for the court to authorize stingray, but it does not stop any law enforcement officer from using a stingray without court authorization. And with ordinary wiretaps, you do need court authorization to do a wiretap. Stingray should be the same way. It should actually require court authorization to use stingray, so that part of the bill could be stronger. But I do think this bill is overdue. I know it's come up for several years, but it is time that we pass this bill. Thank you.
Thank you, Randall. Any questions for Randall Rose? Seeing none, that ends testimony on House Bill 5866, which brings us to Representative Place's bill, 5429, and it is an act related to property, form, and effect of conveyance. It allows a municipality to publish any public notice in a newspaper within the municipality or any other platform selected by the town or city council of said municipality.
Thank you, Mr. Chairman. I think that there's like drafting error in terms of affecting it just on one particular piece of the code, but the intent of the legislation broadly is to allow municipalities that don't have wide-scale circulation by traditional print media to use alternate forms of alternate forms to get their message out. Right now, if a municipality wants to issue a required public notice, they have to issue it in a print media that is in wide circulation. I just don't know there's one that I just don't know if there's one that exists today. I mean, if you look at it, the Providence Journal is probably the most widely circulated paper in the state. I don't think it gets to 10% of the people that actually live in the state. So the intent of the law is to allow for proper public notice of what's going on inside a community, but unfortunately technology and the business of the newspapers has caused it to be kind of an archaic thing and just an additional cost that municipalities have to go through in order to notify their citizens what's going on. An additional issue that comes up that actually was brought to my attention is, in some cases, municipalities rely on a weekly. So if they have if the weekly is published on a Tuesday, but they have something that comes out of a meeting on Tuesday that needs to be published the next day, or is authorized to be published the next day, it won't be published for another week, which puts a lot of things behind schedule. For instance, if you've got a request for proposal or something like that you issue, it's now going to take you a full week to get that going, which puts the project behind by a week right off the bat. So again, the drafting, it's very specific. It's a very specific point in the law, in the law, but the intent is to allow municipalities to use Facebook or something like that to more broadly distribute the public notice. Because, quite frankly, you can go on Facebook and you can buy an ad and boost a post for $15, $20 and reach within your community half, if not more, of the Providence Journal's entire reach in the state. So it's more effective and it's more economical for the municipalities. And in my mind, it's one way to relieve one of those small things we always hear about, the unfunded mandates. And this would relieve them of one of the smaller but most obvious ones out there.
Good bill. Any questions of the sponsor? Seeing none, there are no witnesses to sign up, so that completes testimony on Representative Place's Bill 5429, which brings us to the second last of the bills, sponsored by myself, 5472. It's an act related to property, conservation and preservation, and restrictions on real property. It requires that conservation and preservation restrictions that they be liberally interpreted in favor of the grants that have been awarded. And we have one witness, Rupert Friday from the Rhode Island Land Trust. Rupert.
Good evening, Chair Craven, members of the House Judiciary Committee. Thank you for this opportunity to testify on House Bill 5472. And thank you to Chair Craven for sponsoring this legislation. I'm Rupert Friday. I'm director for the Rhode Island Land Trust Council, which is the state coalition of over 45 land trusts that are working to protect the special places in our communities. And we support House Bill 5472. This amends Rhode Island's enabling legislation for conservation restrictions so that the legislative intent is clear that conservation restrictions are for the public benefit. This provides the courts the basis to uphold a conservation purposes and the intent of the property owner when they record a conservation restriction if there's ever a dispute about the meaning, intent, or application of the conservation restriction. A little background about the need for this legislation. The bill's proactive, and it's based on national discussions about conservation restrictions. In 2018, the National Uniform Law Commission Conservation Easement Study Committee studied the need to update the Uniform Conservation Easement enabling legislation. In the end, the study committee decided not to update their model legislation and to leave changes to the state. The study committee identified a number of best practices, and one was clear legislative intent that the conservation easements are for a public purpose. In a couple other states, legal problems have surfaced when conservation easements are challenged in courts, and we're trying to avoid this problem in Rhode Island. So H5472 clarifies that it's the state policy conservation restrictions are for the public benefit, and we encourage your favorable report on this bill. I'm happy to answer any questions.
Any questions of Rupert Friday? Yes, David.
Mr. Friday, when you say public benefit, how do you define that? I know there's different definitions of public benefit. And I'm just wondering from your perspective.
Yeah, so conservation easements are restricted, are recorded, for example, to protect farmland or to protect forest habitat, wildlife habitat, and so the benefits are keeping the farmland there for the community, and it's recognized that way in the federal Internal Revenue Code, so that people can get charitable contributions for donating a conservation easement. So it could be a view that's benefiting the public. It could be maintaining farmland in the community so that you have long-term ability to supply locally grown food. So that's how public benefits seen.
So in that definition, do you include actual public use of the property?
Not necessarily. For example, most farm conservation easements do not include public use because it would be a real problem for the farmer if people were trespassing on their land to, the public benefit could be the view. It could be, in the case of the farmer, it's keeping the farmland. It's keeping the farmland it's keeping farmland. So it's not being transferred to other uses. So it's there for a long time.
Thank you.
Any further questions of Rupert Friday? Seeing none, that concludes testimony on House Bill 5472, which brings us to our last bill tonight, sponsored by Representative O'Brien. It's 5618. It's an act related to pets and animal husbandry and contesting a pet ownership. It creates a legal process by which formerly cohabitating parties could seek from the district court a determination as to who the owner of the pet is. Representative O'Brien, I don't think, signed up. He must be otherwise occupied. There are no witnesses. So that concludes testimony on House Bill 5618. And do I hear a motion to adjourn?
Motion to adjourn.
Second.
All those in favor signify by saying aye. Aye. Opposed,
Aye.
nay. The ayes have it. Thank you very much. Great job.
Have a good night.
Good night.